All right, everyone. I'm going to try to do this, and I'm learning new tricks, so I'm an old dog. My apologies if this gets less than effective, but we'll do what we can to make it work. I spoke at the NCLC conference a few days ago on October 26th with Peter Silva, a good friend of mine, Jeff Gentes, a guy I've gotten to be good friends with. Had a good time. We're able to share, and I wanted to go back through all the slides from this presentation and be able to add a few more things in and sort of go through a little more detail in a couple of places. So with that in mind, I'm just going to jump right in. Hopefully this is working correctly and recording my screen as well as my video. So we shall see. Now, if we're where we're supposed to be and this is working correctly, then we're going to talk about the overview of these cases. In essence, what is it, that we're trying to do, and really what we're looking at with these cases is how do we turn these into the types of cases that we want to have as cases we can take in front of a jury. So we're looking for what's important in the cases, looking for how do you get the evidence of what's important in your cases, and then what do we do with the evidence when we have it. So I always like to call them mortgage cases. We refer to them in my office as break-in cases. Basically, what we're looking at is essentially, I call it legalized burglary. So the way this goes down is your client goes into default. On the 40th day of default, under most servicing guidelines, there's a requirement that the vendor do a drive-by inspection to determine whether the home is vacant or occupied. This process in and of itself can be problematic because what you're going to get into there is someone who's being paid a couple of bucks to go by and take a few pictures of the house, make a call about whether or not the house is actually someone living in it or not. These usually occur during the 9 to 5 hours when most people are away from their home at work. So it means that those people are in essence in a position to come by when no one's home. And since no one's home, they can decide for any number of reasons that the house is vacant. And what happens is you start this sort of daisy chain of problems where you get into trespass and theft. And generally that's done in the name of the lender taking reasonable action to preserve the collateral. People who go into your house, they're not employed by Ocwen or Wells Fargo or any other major servicers. They are vendors who are hired by some other company. And what we've called it is a daisy chain of agencies and sub-agencies where, in essence, you have a group of people with very little to no accountability who are, at least on the surface, who are going in and essentially robbing your clients. So the who's who, you have the lender or the note holder or the investor. That could be Fannie, Freddie, could be a private trust. Generally, nowadays, it's almost always going to be a government-sponsored enterprise of some sort, FHA, FHFA, VA, HUD, Fannie, Freddie. Then you have the mortgage servicer, which we're all very familiar with, the ones that tend to screw up everything they touch. Technically, they're responsible for preserving the collateral, handling payments, and applying the money correctly is a whole other topic of a completely separate presentation. Below the mortgage servicer, they generally have a contract with a national field services company, Safeguard, LPS Default, one of those type companies. And then that national company has a regional property preservation company, which may only deal with one state or could deal with a couple of states, depending on the volume of work. And then the regionals are responsible for hiring people who actually go out onto the property and do the work. That's your local property preservation company. So what leads to property preservation? I think I said 40 days a minute ago, and 40 or 45 days. I'm not going to quibble with that number. But the mortgage servicer is required to start exterior inspections. It's the euphemism of the day. We always refer to them as drive-by inspections. And that's supposed to take place every 30 days during any period of default. So the drive-by inspection, usually it's going to be some 20-something kid, and that kid is going to be someone who has very little life experience, number one. Also looking for a job, and in essence, they're looking for anything they can do to make a living, get very little training, and they're sent out to make a decision about whether or not someone lives in your house. The mistake can be catastrophic, because the mistake, finding that your house is not occupied, can lead to this home invasion. Sorry for that brief interruption. So once your drive-by inspector comes out, their basic task is to determine occupancy and document the condition with photographs. We hear all kinds of stories about things they're supposed to do, but generally these people are expected to be at the side of your property for less than 5 minutes. They, in theory, are supposed to be able to take their pictures and make a determination without you noticing they're there. That makes it kind of incredibly hard for them to find the meter on your home and determine whether there's power running. But best thing you could do in that scenario is make sure you leave the light on, so to speak, so that front light. So if anybody takes that picture, they would see, in theory, you'd have a visible light, would show there's electricity on or some light visible in front of the house. But we can't counsel everybody, and that's not really a very good excuse for what they do. At the end of the day, we've had plenty of cases where the utilities show there was no interruption of service, but you have a drive-by inspector saying that there's no meter or no electricity at the property. It's always important to be very thorough about the drive-by inspector's deposition and find out things like what the default settings are on the apps that they use to report. For the longest time, Aquan in particular, their quote-unquote separate entity that did their exterior work, their app was set by default to vacant. So if someone was just in a hurry and forgot to set it to occupied, you could end up with a home invasion, basically, just because someone failed to tap a radio button on an app on their cell phone when they were taking these pictures. So when you spend time with your drive-by inspector, make sure you get as much information as you can in that regards. Make sure you do a good job getting as much detail as possible about settings and how long they spend and how many they do in a day and how far they drive between, all those kinds of things. Because, again, this isn't a very good job for an independent contractor if they're getting $2 or $3 a house. They're supposed to be done in 4 or 5 minutes, but then they got to drive an hour between houses. So you definitely want to get into that situation and figure out exactly what's happening there. Then once there's a determination or a report that the house is vacant or unsecured for the first time, the system automatically takes that finding and automatically generates orders. And when I say the system, I mean the mortgage servicer. They automatically generate orders to secure the property. Securing the property means, in essence, they're going to change the locks on the house. They're going to winterize the house if it's the right time of the year and the right locations. They're going to inspect the interior of the home. And that generally occurs within 7 days of the first vacancy report. Sometimes you get testimony that there's someone from the servicer or a national company reviewing loan activity to confirm vacancy report makes sense. I've never found anyone who would raise their right hand and swear that they did it. There's always, in the better cases, there's lots of issues in the pictures usually that show that, the house likely wasn't vacant, at least left doubt. So always pay close attention to the pictures that you recover when these cases are going on. Another thing that the inspection report is supposed to identify once the secure order has gone in is whether there's any interior repairs that are needed. And also, there's usually an order for what we refer to, or what the industry calls, a trash out. And what that means is all the personal property in the home is either stolen or thrown away. The industry says they're not supposed to keep anything, but usually what happens is they loot the house of everything valuable or everything they can sell cheaply and easily, and then they throw anything else away. You'll get a lot of testimony about what the processes and procedures are supposed to be, but quite frankly, the one consistent theme I've always seen in these cases is the opening set of pictures always looks like like a tornado blew through the house. Everything's thrown out on the floor. Everything's dumped out. Essentially, what we believe is happening is that the folks are essentially searching the house and making it look like it's not taken care of by throwing things out on the floor and slinging things everywhere, making it look like it was just trashed, in essence. Just imagine someone broke into your house while you're gone for a long weekend and decided to vandalize it and just dumped all your drawers on the floor, threw everything that you ever had out on the ground, walked all over it, broke it, picked through it for valuables. It looks like the scene of a burglary because that's pretty much what it is. So, but in theory, this is supposed to involve removing all personal property and cleaning out the house so that it's in what's called broom swept condition, so that there's the ability to, in essence, take control of the house and prepare it to be sold or to show to a potential buyer. So we get some variance in the fact patterns. All these things have some relevance to the ultimate value of the case, but you always want to know whether the house is being alleged to be vacant or abandoned. You want to know what the real property condition was prior to this. You want to know about borrower interactions with the mortgage servicer. One thing we always are flabbergasted by, and I think most people are, is that you'll have a borrower in more or less constant communication with a servicer. If they're in default, they're generally, in a judicial foreclosure state, they're generally communicating about loss mitigation, communicating about how they can keep their home, either directly or through counsel. And no one ever asks these folks, do you still live in the home? Is the home still occupied? Et cetera, et cetera. So when they get this first drive-by inspection, it says, no, it's not. They could have been on the phone with the borrower at the time the inspection took place. They don't care. They never look at their notes. They don't call the borrower and say, hey, we talked to you yesterday about saving your home, but the drive-by inspector indicated that your home was vacant, or, we're still trying to confirm you're living there. You want to keep your home. Any of the things normal people would do to, before they broke into someone's house and threw away all their personal property and all their keepsakes and, kids' pictures and wedding photos and ruffled through their underwear drawer and that sort of thing. Stole everything that was valuable. So lots of facts in those scenarios that make for good law and good damages claims. You also want to know what the orders and instructions were when people were sent to the home. What were they told to do versus what they did. You want a good inventory of what was damaged or taken. A lot of times, the pictures themselves will show you the things that were damaged or taken. Now, I remember one of the cases I handled, we had some pictures from the master bedroom where the people who went in the home to quote unquote trash it out had clearly separated things that were very valuable from things that, arguably not. For instance, in that case, we saw, fur coat and a wedding dress, and it was designer that had been put up and kept, as well as some jewelry and things in one stack. And then in the other stack, we saw like empty shoeboxes, things like that. And that picture was just randomly mixed in with all the others. You should always, all these people testify that they have a before, during, and after photo set up. So even when they go in and trash the house, they're supposed to take their before pictures. It might be that they've already looted the house and everything's slung everywhere, but they have to identify what are their before, what are their during, and what are their after pictures. So, that's important to know if you've not dealt with these kinds of cases. And then, to the extent you can, also, you want to try to find out what happened to what was taken. We have a case recently that we were told, we take everything to the dump. And then, we got some testimony that, well, on the way to the dump, we spent 2.5 hours at, this local property preservation person's warehouse. So, pretty good indication that they had lots of time to take that dumpster and, isolate the things they thought were valuable before going to the dump and dumping the things they didn't think were valuable. You often get gifts in those types of cases just by being willing to run down the rabbit trails and flesh out the testimony and really develop as much detail as you can about what these folks are actually doing. My colleague Peter, he wanted to attach this particular document because the house in the blue there, and this is in DC, and these are row houses. A drive-by inspector said that the power was not on and that this house was not properly maintained. So, very clearly, you can see that there's, fresh cut flowers. Everything seems to be well manicured, well kept. There's no broken glass. It's the middle of the day, so there are no lights on. That sort of thing. We did our panel. We had stories that were told, and one of the stories that was interesting was the person who put their a sign on their front door, literally, that said this house is not vacant. I live here, because they had had someone come out and threaten to go in their home before. So they were kind of afraid to leave to go to work without something there, allegedly as a warning. And even after taping that sign at the front door of the house, people just went right past it and straight into the house. So, interesting. That's another great sort of failing of the way this system works is that there's no real accountability to exercise independent judgment and make a good decision based on what's actually happening there and what's really going on. So, you see all kinds of things when you start digging into the details of these cases. So legal theories, I do a lot of these cases in Illinois. In Illinois, we have the Illinois Consumer Fraud Act, and it actually has a much longer name. We all refer to it as the ICFA. It has two prongs to it. One is misrepresentation, and the other is unfairness. We typically proceed under the unfairness provision because it's relatively easy to prove, and it's more or less lends itself to ease of access in the sense of being able to reach punitive damages and attorney's fees, fee shifting. These cases are definitely about trespass and invasion of privacy, and we use the intrusion upon seclusion element or prong of invasion of privacy, which is one of those things where the law presumes damages. In Illinois, to get intrusion upon seclusion, you've got you need to show that someone accessed sensitive material such as financial records, medical records, that sort of thing. And one of our cases up there, the Thacker versus Aquin and others, which is a pretty well-known case on this subject in the Northern District of Illinois. We had contractors who went in and threw away bags of medicine, and they also rummaged through drawers and took bank statements and cash that the client had been saving to remodel his kitchen. But intrusion upon seclusion was able to go to the jury based on the finding that the medical records and the medical information in the pharmaceuticals and prescriptions was enough to trigger sensitive information along with bank statements. So those things got us home on that point. If you don't have diversity jurisdiction, oftentimes there's a RESPA claim. You just have to make sure you know what your RESPA claim is, make sure that you have done your work to make sure that's a good claim before you file suit. Some lawyers file breach of contract claims. In particular, I personally am not fond of that. It tends to be a distraction, gets in the way of the better claims. Negligence, that's very state specific. Most of the time, you have this comparison of whether something can be negligent if it's a breach of contract. You don't typically have a duty in this scenario that doesn't begin with the contract between the parties. So personally, I typically don't use breach of contract and negligence very often. I do like civil conspiracy count because it covers, an expansion of the liability by basically proving that each actor in this chain of relationships played their part in reaching the outcome that was illegal, which was the trespass and intrusion upon seclusion. In that scenario, there's also a restatement of torts that's recognized in Illinois in particular, dealing with causing a third party or another to trespass. And the party responsible for causing a third party to trespass can be directly liable for the trespass themselves as if they were the person who did it, even though that doesn't fall within traditional agency rules. So oftentimes that can be available even if there's no direct agency scenario. So yeah, that's definitely one way to look at that. And again, the Thacker decision has a great discussion of that. But, to really prove what's nefarious, you absolutely have to understand the industry, the way that they work, and all these rules are sort of put in place by the GSEs and basically manipulated for profit by the actors up and down this chain. So in this particular slide, we're talking about the different ways that we've used some of these laws to attack some of the arguments. Basically the determination of vacancy being unreasonable. At the end of the day, that becomes more of a jury issue because if the trespass occurred, it's relatively strict liability unless it was excused, and it's usually not excused in this scenario. But focus on proving through your discovery and testimony that there were lots of ways they could have found out that the property was not vacant or abandoned, including just having a conversation with the borrower that they were talking to every day about loss mitigation or foreclosure or their bankruptcy or something. Under the Unfair and Deceptive Acts and Practices, we talk about the idea that the process and procedures are unreasonable, unfair, illegal, they cause significant consumer injury, and the mortgage servicer and the National Field Services Company know that those things occur when they order these actions. Direct and agency liability, again, we like the conspiracy count because it brings everyone in for their own liability and the liability of everyone else. We emphasize strongly the direct liability for the trespass and intrusion upon seclusion that occurs, as well as the agency liability. Understanding emotional distress damages. If you've dealt with very many of these cases, it is not hard to understand the emotional distress aspect of this. What I always tell people who don't understand these cases is if you just think, if you walked out the door this morning and you went to work and you got home at 5 o'clock and the locks on your door were changed, you couldn't get in your home, there was a sign up that said, call your mortgage company. And so do your best to try to get into the home. Can't get into the home, you call the mortgage servicer. They give you a key to, or a code to the key box. You get in your home and you find out that your baby pictures are gone. Your wedding pictures are gone. Tax returns are gone. Bank account statements are gone. Your diary's gone. Your prescription drugs are gone. Your videotapes of your kids playing sports, gone. The video of your wedding, gone. You don't have to think very hard about the types of things that are lost in this type of scenario to understand the significant harm that normal people suffer when these things occur. And A lot of things I just mentioned don't have a lot of dollar value. And that's because, honestly, they're priceless. You can't get them back. They're gone forever. And, they're irreplaceable. In my own life, I had a fire when I was a young man, 20, in a house that it was clearly burnt. I mean, we had not even moved in the house yet. The power wasn't even on. Someone burnt the house down. And while very little of our belongings had been moved into the home, my letter jacket from my state championship team was in the home because it was summer. And obviously, I was 20, 21 at the time, so I didn't really wear my letter jacket very often, but it meant a lot to me. And I had a pair of elk skin boots that were super important to me. First pair of boots I ever bought, and they were there. And so that with a couple of other of those types of things, but the two things I remember the most, a letter jacket and a pair of boots that were important. And I was still smart about that issue. And I know that it still irks me. And it's 30 years ago. I remember it very well when I found out that the house had been burnt and things inside were gone. It was a lot like a punch in the gut. So it's easy for me to put myself in position of most of my clients in this scenario because I've lost things that matter to me in unexpected ways, and I know how it affected me. So it doesn't take a lot to build off of those stories and really build up, what's happened to the client. And then, beyond the client story, then, I always turn to friends and family witnesses who are key to developing this story about how the client's been changed, how they've been harmed. I've had clients who couldn't go back in the home, couldn't sleep in the home, couldn't live in the home, nightmares, people going to break in and murder them, that sort of thing. And if you don't have any of these experiences in your own life, someone in your circle does. Find someone who's had their house broken into, had their car broken into, had a fire where they lost things, had something of this nature happen, and really understand at a personal level what it does to the person. And once you can feel it a little bit in your own bones, it'll certainly help you communicate it to a judge and a jury much better. And then punitive damages, punitive damages should always be in play if your state allows punitive damages for trespass and invasion of privacy, intrusion upon seclusion. If you have a good state unfair and deceptive acts and practices law like Illinois does, you also have punitive damages available there. And in some states, you can get punitive damages for your conspiracy count depending on the underlying wrong. So if the underlying wrong is a tort that allows for punitive damages, then conspiracy will also allow for it, at least in my own experience. So getting what's important from the client, we always want to get whatever correspondence we can from the servicer, whatever documentation and proof they have of ownership of everything that was damaged. We also want to get proof about the vacancy, any insurance claims, any police reports, utility bills that tend to show that the home was occupied and service was on at the time that this occurred. Of course, a lot of times the break-in pictures themselves will show that the lights are on in the house because you got to remember, the folks that went to break in the house are not the folks that did the drive-by inspection. It's a different company. So they don't really know that the drive-by inspector checked a box and said the power was off. They just know that when they got there, power was on, gas was on, water was on, cable TV was on, whatever. And then, to the extent your doctors have seen therapists or physicians, definitely go ahead and get all those records as well. When you send communications to the servicer about this issue, you're going to be requesting inspection reports, mortgage servicer's notes log, transaction history, and all their communications internally and with their vendors about, that would include things like orders for this work to be done. So that should get you all that. And then you want to get your vendor data from vendor apps, which we'll talk about in a moment. If this is one of the major players, then you're going to be looking for other similar incidents, which constitute notice and knowledge of problems with the conduct in your case, and knowledge of the great needless harm that a consumer will suffer if this is done improperly. So you can always go to the CFPB's complaint database, AG's offices, Westlaw and Lexis. You can sometimes find cases that are reported, Better Business Bureau, and then, of course, your friendly neighborhood, consumer lawyer listserv. You also want to go to your GSE servicing guidelines and look at what's actually required. Make sure that you're looking at the version of the guidelines that apply to the time frame with which you're working. The Edgar website can also give you a pooling and servicing agreement if your loan is privately owned in some instances and it's been securitized. It used to obviously happen a lot more than it does since the financial crisis of 08-09. Back then, we always went to Edgar to get the PSA or the pooling and servicing agreement. Nowadays, we almost never need to do that. Your property preservation vendor website, lots of great information, as Peter noted during our joint presentation on the 26th. Sometimes they have handbooks and policies on the website. You can actually download them. But they almost always have a lot of platitudes about how and why they do things and how their interest is in, getting it right, etc., doing things the right way. Usually some nice material there to beat them up with at some point in the process. So, you want to always ask for, in discovery, the contracts between the various actors. You always want to get your inspection reports. You always want to get your policies, prior internal complaints, and basically invoices, photos, communications, payment logs, and the property preservation platforms, database communications. E-discovery is such a big part of what we do. It's well worth the time and effort to dig in and find out how these people communicate, how that information is stored normally, and hopefully find what you need. We had a case where had a mortgage servicer who will remain nameless for purposes here, who said, we don't have any complaints. We don't keep up with those things internally. And then we went and deposed a couple people who weren't the talking heads for the company and got a manual produced. And lo and behold, about the 10th page of the manual, there's a couple pages to talk about how important it is to track allegations that would go on in people's houses improperly, and where to save it, and where the spreadsheet is that tracks it with all the relevant communications and facts and all the information is supposed to be stored there about these events. And oh, by the way, here's how you get to this particular file on our firm, on our company drive, and literally had, and what you and I would recognize as a network drive address to take you right to the folder that the lawyers had been saying for a year didn't exist. So, needless to say, there was some splaining to do when they got back in front of the judge. When you're dealing with these issues, property preservation, there's, people who go out to the field almost always have what's called an Aspen Grove number. Aspen Grove performs a criminal background check for the exact amount of time that's required by the GSEs and no more. Aspen Grove assigns everyone they do a background check on an Aspen Grove number. You can subpoena the entire Aspen Grove file for that Aspen Grove number. That's something you should definitely do. Also, a lot of companies use PPW, Property Preservation Wizard, or Exactware. Those companies can also be subpoenaed, and you definitely want to get things like their versions of the photos that are uploaded before they're time-stamped, etc. Because a lot of times those files and photos will contain metadata, which is contradictory to the defendant's version of events, and oftentimes impeaches their story dramatically. So being very thorough, getting all this information is of huge importance. Also, you want to get your utility company bill showing the property had active utilities if that's an issue in your case. And also, you want to get your doctors and therapist records. You can get all those things through third-party subpoenas, and probably simpler if you get ahead of that and try to do that early. So, you're in litigation. You've done your paper discovery. Who do you depose? The consensus in our presentation is you always start at the bottom of this daisy chain, and you work your way up. And you want to start with the people who went on the property, and then you want to start on the people, who did the drive-by inspection to determine vacancy. Then you want to, go to the people who are making the decision to trespass, and then you want to go to, the owners or corporate reps of the companies that are down the chain, and you want to, examine not only their actions, but what they understand about the property they're entering, what the banks tell them, or the mortgage servicers. You want to understand their financial incentives to go into the property versus refrain. But essentially, the key to this entire scenario is the financial part of it. I mean, quite frankly, the way this business operates, no one can do it profitably unless they're stealing stuff and selling it. The people who go to the house to do the work, they don't make enough money to do it in a way that's not criminal. A lot of these guys are getting paid, less wages than someone working at Denny's. Waitresses' tips of $2 an hour. And all these companies tend to call all their workers independent contractors so they don't take taxes out on them, etc. And essentially, they might pay somebody $50 to go spend, 16 hours cleaning out a house. And, it doesn't take long to figure out that ain't a whole lot of money. But if they find $5,000 in cash in a drawer that never makes it into the inventory of items that they've pulled out of the house, well, now their hourly rate just got a whole lot better. And so we see that more or less constantly with these scenarios. And the other thing that we often see is these people testifying that the bank told them that they already owned the property. It had been sold. It was theirs. So that becomes a very common scenario, and that becomes justification in these people's minds for, taking people's stuff and stealing it, making it theirs, or selling it for whatever they can. As part of showing how unreasonable these things are, you always want to be able to show property wasn't vacant or abandoned. You can use the testimony of clients, family, friends, neighbors, showing that the client's mail still went to the address, that they had active, utilities. Oftentimes inspection reports and photos do not agree with the descriptions that are given by the inspectors. A lot of times you have perfectly manicured lawns, perfectly kept homes. Sometimes you even have utilities on in the pictures when the inspector says there are no utilities. So we've had inspectors say there were broken windows, etc., when there were no broken windows. So those are always nice little gifts. And again, it comes down to knowing the evidence in your own case. Another place that's always fruitful, again, is what's called the notes log in the mortgage servicer's file. And, we've even had cases where people were talking to the borrower about loss mitigation. And in the same breath, they're talking to these property preservation people about breaking in the house and it's abandoned. So always look for those scenarios to find out, whether the servicer even acknowledges that they were, dealing with the borrower about a workout situation when this occurred. They always say that they don't have to, but, I think normal people who sit on a jury think that they're idiots for saying those kind of things, and they don't typically turn out well for them when they make a lot of stupid comments, when it would have been just as easy to pick up the phone and call Mr. Smith or Mr. Jones and say, hey, we were talking about your house and this inspection says your house is vacant. Are you still living there? That sort of thing. The adequacy of policies, procedures, and practices. The distinction between vacant and abandoned, even that is a major difference. And if you're dealing with the difference between vacancy and abandoned, then that can make all the difference in the world. You can have a vacant home where someone's trying to do a short sale and they're working with their mortgage servicer, and the house is clearly not abandoned in that scenario. But if the standard is abandonment to enter and change locks, it never works, never meets that standard. But it could be vacant in that scenario. So, another thing that Peter had seen in one of his cases was the idea that the amount of money owed was too small to make what they did reasonable. A client who owes $5,000 on a mortgage, and the bank goes and does this, and they charge outrageous fees and charges, and all of a sudden the borrower allegedly owes $50,000. Those are the makings for good cases. When you talk about policy and procedures, a lot of times you get really good evidence that all that is smoke and mirrors, really not what happens. They really don't care. For the servicers and the property preservation companies, their goal is to churn services and charge fees and make money. And when someone gets into a short default period, they're really just doing these things in a way that's designed to drive people out of their homes, cause them to give up, throw their hands up, walk away. You don't want to, have those situations come up. But that happens. And again, very good subject for examination during your depositions, sham inspections. Again, we've had people that take 3 pictures of the front of the house and say they have a picture of the back of the house, they have a picture of the, meter, say that the meter is not present when the meter's in the picture, all kinds of things. And it's pretty apparent from doing the work that no one really ever looks at those things until you sue them. For them, it's just a cost of doing business. The financial incentives, to me, this is the heat in these cases. Let's say that there's a $600 fee for a project. what you tend to find out is that about 60% of that goes to the national field services company, who does nothing but send an order for the work to be done. They send an email. And then the regional gets that email and they send it on to the local. And then they take about 30% of that, Fannie Freddie allowable for that property preservation. And then, the person, the poor bastard who actually is supposed to go out and do the work, they get about 10% of what the government intended to pay as a reasonable fee for the work to be done. And of course, can't make a living. If you drive out to a house to do a secure and you find out it's actually occupied, you don't get paid. Well, if your gas tank is, almost empty and you don't make any money, get in that house and find out whether there's, a couple $100 laying around. It'll be pretty important. Might be the difference for some people between eating or not that day. So a lot of these people are doing this, or, they're in a bad way. They don't have the economic outlooks are very poor. Some of them are felons, former felons, and they're trying to find anything they can do to support themselves. And this work kind of lines up because they, unfortunately, some of them have familiarity with breaking into houses. So this isn't anything new for them. But when you look at the amount paid for an inspection, the amount paid to secure a home, the amount paid to trash out a home, it's generally pretty easy to show that financially the incentive is to go and steal, because that's the only way to make it work financially. The mortgage servicer's lack of efforts to determine occupancy after an inspection finding vacancy, that just never seems to sit right with anyone who hears the stories. Always seems to be a hot point. The mortgage servicer never challenges the findings of vacancy, even though they know they're talking to someone about saving their house, and they're on the phone with them for an hour a day about gathering information about a loan modification. They never tell the field services company, well, I'm dealing with that borrower right now, and they told me yesterday they live there. So, the other part of it's kind of ironic is one of our panelists pointed out, is the idea that, in effect, the mortgage servicer charges the borrower to break into their house and rob it. So all these fees are referred to as allowables in this system, in this process. Those get charged to the borrower's account. So in other words, you've paid someone to break into your house and steal all your stuff. So I think most people find that outrageous. It doesn't tend to sit well with normal people. I think only folks in the mortgage industry think it makes any sense. And when it's riddled with the kind of problems we see, it doesn't tend to go too well. The other piece of this is the computer systems, which tend to automatically order these things to occur without any human input or consideration, other than to set the timeline to do the order. Those things don't tend to sit well with people either. So, your principal agency issues in these cases dealing with direct or agency liability for the servicer and the National Field Services Company deal with the direct harm caused by their own conduct and the idea that these duties are non-delegable. If you look at excuse me for that. If you look at the GSE guidelines, Fannie, Freddie, HUD, FHA, most of them that I've run across identify property preservation as a non-delegable duty. And that is to the mortgage servicer, not to anyone down the line. If your state has good law, it's going to impose direct liability for causing the trespass, causing the intrusion upon seclusion, violating the unfair and deceptive acts and practices law by causing the trespass and intrusion upon seclusion. Usually, if you're lucky, you'll have some other state laws to protect home ownership that also are violated and show direct harm that you can recover under a UDAP theory. Under your agents and employees, you're looking at this argument that these people are independent contractors. And again, you go to the language of these contracts and it will make it very clear that these people have little to no discretion. And if you start at the bottom and work your way up, you'll find out that pretty much the person who went into the home essentially believes they don't have any choice. If they want to get any work, they have to do what they're told, and they have to do it. They have to accept these jobs within 24 hours. They can never turn them down, and they have to complete these tickets or it's game over. So you really need to start with those people and confirm their understanding of their obligations. And basically, you have a pretty strong argument by the time you get through analyzing the documents and getting testimony about what the understandings are and how they're enforced. You have a pretty strong argument that this is sort of a sham setup just designed to claim independent contractor, but not something that could ever be legally sustained if it's effectively challenged. Notice and knowledge of prior incidents. We found a PowerPoint, one mortgage servicer's production said claims for removing personal property from homes during the loss mitigation or during the default process. So number one source of financial claims against the company in the previous year. And they were there to allegedly educate their vendors about how to do it in a way that they wouldn't get sued all the time. That company still doesn't have it right. They still do this every day. Somewhere in America right now, someone's probably trashing out a home that people live in that are doing work ostensibly for that particular mortgage servicer. You get CFPB guidance about control over third-party providers. It strengthens your agency arguments. You also get insurance agreements, which show an obligation to insure the upstream providers and indemnify them, which tends to reinforce your agency arguments. And then you also have intentional torts, which most often will impose liability on the person who causes someone to commit an intentional tort, even if they're not an employee and they are an independent contractor. So, one of the best discussions I've seen on this issue is in the Thacker versus Aquin case from the Northern District of Illinois. That is my case. Judge Tharp handled that case and wrote this decision. And essentially, it's a very lengthy opinion, talks about agencies and sub-agencies and the factors that come into the analysis from these various contracts. It also discusses conspiracy liability and direct liability. If you really want to know how to link all these people up, I'd say go to that decision. Follow that blueprint. It's a great sort of step-by-step way to tie all these folks together and get them in front of a jury. You can get them there with conspiracy and this agency argument, which is essentially, what we call respondeat superior. So when we talk about the way we prove the reality of the emotional distress damages, again, my favorite way to demonstrate how serious this is through the testimony of family and friends. It's essentially unimpeachable. It's firsthand observations of what your client's gone through and how it's impacted them. Oftentimes, these stories are both the most poignant and the strongest part of your evidence. Because often family and friends see the reality of the harm that even your clients can't communicate and don't even acknowledge. And so all my recent trials where I've had 7-figure verdicts or 7-figure settlements even, they've involved this friends and family testimony, which is just always just heart-wrenching and very powerful and moving. And, only really stupid defense lawyers ever try to question these people. There's nowhere they can go that doesn't blow up in their face. They either look like a jackass for, mistreating somebody who's only describing what they've witnessed, or, they can say nothing at all and they just leave that hanging in the room like, almost like a cloud by the time you get out of it. I really don't know how to explain it other than you can actually feel that testimony resonate in the courtroom. And if you've never experienced it, it won't, there's no way I can tell you, but if you've ever walked into a room and you just felt the force of energy in that room, be it positive or negative, you can just imagine almost a crushing type weight, the heaviness of the harm and the sorrows that your clients went through. That's usually just hanging in the air when these people get off the stand. And the other thing about it is their testimony is usually 15 or 20 minutes long. It really doesn't take but a couple of minutes to just totally bring home how much hell your clients have been put through. Testimony and records of your doctors. Your doctor's not ever going to say, Mr. and Miss Smith have stress because of the conduct of their mortgage servicer and their National Field Services company. That's not how this works. It's always going to say things like financial difficulties, extra stress. Maybe it mentions fear of losing their home. Maybe it mentions loss of personal property. Maybe it just mentions extra stress, whatever. Doctors are busy people. We all know that. They'll tell you very quickly their job is not to identify a specific cause of a stress or a problem. Their job is to identify all the things that could be causing their client's symptoms or dis-ease state. And, from there, work their way down to the likely causes. It's called a differential diagnosis. And the most important thing for you to know about that is the idea of a cause of harm versus the cause of harm. If you practice in a state where you have to prove the cause, then God bless you, you always have a very difficult task. And, it's incredibly unfair to ask that of you in the context of civil litigation. And it means your law is very heavily tilted in favor of defendants generally. But in most states, it's a cause of harm. And almost any doctor that's treated your clients for any length of time will be able to say that they experienced stress or, depression, whatever, that they had related to these financial stressors or fears or whatnot that can be tied back to your case. You can also generally ask a doctor who's been treating your clients for a while if they've ever had those types of complaints or problems in the past before this issue arose. Most of the time you'll find that they have not, surprisingly. We should all, I guess, fall out on the ground and roll around over the idea that having your home broken into and everything that you own that matters to you being taken causing you stress. That's a real shocker. If you want to look at your case law about disrupting the quiet enjoyment of a home, back in Alabama, it's called the peaceable possession of a home. Every state's verbiage is slightly different, but you look typically in the field of home warranties, negligent construction, the removal of support that causes the foundation of a home to, be jeopardized or whatnot, lateral support or whatnot from a neighbor, or, flooding because of a neighbor's conduct or actions. Anything that damages the quiet, peaceable enjoyment of your home. Most states have some cases out there that says that there's a presumed injury in that scenario. So it's also a nice little way to make sure you're proving good emotional distress damages in today's environment. Then as far as, proving your punitive damages, you're proving that this is not a mistake and that the defendants were on notice of the potential harm. And this is where notice and knowledge evidence is hugely important. It can be prior internal complaints. It can be other lawsuits. It can be judicial opinions. It can be consent orders. The recklessness shown by the facts of the case, the outrageous nature of the action, we've seen sending people who are prior felons to homes to break into them. The break-in process seems a lot like a burglary. I'm always surprised that, there are not more people killed in this line of work because of the number of times you hear about people going in on somebody's house and there being a person there. Certain parts of the world that'll get you dead pretty quick, and no one will ever think a word about it. So, it also puts it in line with the idea that, they're not getting paid very much to risk their lives to go out and break into your house and steal your stuff. So, that goes back to the idea that this whole process sort of depends on the idea of an attempt to legalize theft and burglary under the guise of property preservation. And you can show that it's outrageous by just talking about, the pyramid of, who gets the money versus who does the work. If you flip the pyramid and the people who were just sending emails were getting a small payment, and most of the money was going to the people who had to go to the homes and do the work, you would get a better quality candidate who had more professional staff and could be more careful and who could, in effect, do a better job of what was intended, which was to make the pay for the work reasonable under the circumstances. But the current system is set up to where the national companies are just greedy bastards and they steal most of the money for sending an email. And the regional people are like the little brothers of the national people. Their job is to find someone dumb enough to go work for free and then ride them like they have a saddle until they throw their hands up and quit or go away. In depositions, I found it a good strategy to talk about this payout with the people at the bottom of the food chain. Because a lot of times, the local person, like I said, got $50 to go drive out 30 miles to someone's house and change the locks. And when they find out that, the National Field Services Company got $200 for sending the email with the order, a lot of those people are rightly offended themselves. And sometimes you can get them to vent some of their other complaints about how they're treated and help set up this part of the case. So, determine who's going to be finding the facts in your case, who would be awarding a verdict. Is it going to be the judge or is it going to be the jury? You always try these cases on the idea of the defendant's outrageous conduct, not what happened to your client. What happened to your client becomes a small piece of the overall story. after you have piled up wrongdoing at every level of this chain, from the local person all the way up to the national mortgage servicer or the investor even. Once you have all of that done and you've proven that all these people don't give a damn about homeowners, because they don't, you're able to argue to the jury that they are defending the neighborhood, maybe even their neighborhood, and the sanctity of the home for everyone in their community. And, your client's experiences and damages flow through the prism of the wrongdoing. And so in a perfect setup, what you're arguing to the jury is, this happened to my client, and they know that it happens to everyone they do this to. And so, for you to stop it, you have to make it so expensive that it's no longer financially appealable or appealing to engage in this type of behavior and generate the financial incentive to get people to move forward and do it the right way. And, that's a good argument, whether it's to a judge or jury. But I think jurors tend to become much more upset and violent about their reactions to this misconduct, because they see how outrageous it is for the idea that they could leave for work and go home and everything they own be gone over someone failing to click a radio app button on an app that says, vacant instead of occupied. Literally, that one thing can, in essence, turn the whole thing upside down and start a daisy chain that ends up with your client essentially being stripped of, everything they own that matters to them. Always be familiar with your law as to whether it's necessary to show some economic harm to get past summary judgment, and also whether it's necessary to talk about the economic harm in framing your claim, because the dollar value in these verdicts is not from your economic damages. The dollar value in these verdicts is from what people are put through by having their security and peace in their home destroyed and losing their most valuable possessions, and things that are irreplaceable, that no amount of money will ever get you back: your wedding photos or your baby's photos or your kid's graduation photos or your state championship letter jacket. So those types of things are things that people really relate to and that really turn the dial in these cases. Case selection is important. When we do these cases, we're looking for 7-figure outcomes, and you want to make sure you've got a clean case. And then as the case develops, you want to make your decisions about what to try versus what to settle. And you prefer not to be in a situation where you need to settle a case. In a perfect world, you don't have any need to settle a case. You can go to trial if that's what you need to do. So, great advice from former Chief Justice Sonny Hornsby, the Alabama Supreme Court. I was fortunate enough to know him as a young lawyer and hear a few words of wisdom. And one thing he always said was, the problem most lawyers is they want to settle their best cases and try their worst cases. And he said that's the exact wrong way to do things. And I've never forgotten that. And it made a lot of sense and an impact on me. And I hope you'll take that into consideration when you're thinking about what to try and what to settle. Settle the cases that have problems. Settle the cases that have warts. Cases that have clean facts and good facts. Take those to trial. Take the ones that no one can defend to trial. Take the ones where, the wedding photos and the baby photos and the graduation photos are all taken. Those are the ones that, you want to try. a member of NACA. If you're not a member, you should join. NACA, NCLC. They've invited me a number of times to speak. I'm always glad to do so, always happy to contribute, and always glad to be part of a wonderful community trying to help and do more for the everyday consumer who's generally being abused and run over by corporate America. And oftentimes, this work lets me do my favorite thing, which is sue the assholes of the world and get them in front of juries where I can prove that they're assholes and that they ought to be smacked around by the jury. So love the community, love what they stand for, just like I love the trial lawyer community, and I'm happy to be part of all those organizations. Thank you for your time and listening to what I had to say here. Happy to have any questions. Always happy to respond and try to work out some way to be available to answer questions and concerns you might have or kick things around. Look forward to more videos in the future. Hope you enjoyed this one. And we'll be back with you soon with fresh material. If you like the video, do whatever it is YouTube says do. Something about like and subscribe.